The woes of this world is the everyday man's problem. The woes of this world, the issues of this world, is the burden of the everyday man and the everyday woman. This is because someone who has some issue in a completely different circumstance can take it out through the nature of their job, or someone who's gone away so much with something that's egregious, or they feel they can just get away with it because they know the other end don't know better. That state of mind becomes someone else's burden. Most people who are taken advantage of only know how to perpetuate the issue because that's all they learned. So now when it comes to them trying to fix the issue, they don't know what to do. They hear certain words, but are not quite sure exactly how it works. Here's a helping hand in how one of those common terms called counterclaim works. In previous videos, you've probably heard me speak of counterclaims. Counterclaim is just nothing different than a counterpunch in a battle. There are two types of counterclaims, and there are two ways to bring a counterclaim. Well, three. There are three ways to bring a counterclaim. The first way to bring a counterclaim was entertained in this video, whereby whatever ongoing case within 90 days to 120 days, you remove it to a federal jurisdiction by doing a notice of removal. And within that notice of removal that you will file in the inferior ongoing case or the inferior court or whatever court to which you bring in a case from, you just do a notice of removal. That's it. And then within that new case, instead of you being a defendant, you now become the plaintiff because you now have your claim so long as the claim that you have arose out of the initial claim to which you removed the initial claim from. Someone said, hey, you did something wrong, so I'm suing you for it. You go, wait a second, you violated me in the process of you saying that I did something wrong. So as a matter of fact, even though you're suing me, I am now suing you. That's a counterclaim. One of the ways to enforce the counterclaim is through a notice of removal by creating a whole separate jurisdiction on a federal level. Usually most people are sued on a state level, unless it deals with drug or some type of counterfeit or things like that, whereby there are federal charges or tax matters where the IRS is involved. So that's one way to do a counterclaim. And the introductory aspect of that has been explained in this video on YouTube called Removing Case from State to Federal, Notice of Removal, Counterclaim. Let's go to the details of things because, well, what if you're in a state court and the deadline for a federal counterclaim, aka notice of removal, has ran out? What do you do? That's the remedy on a federal level when it comes to counterclaim. On a state level, you can do the exact same thing if the federal timeline and deadline has run out. A counterclaim. In a court of law, a party's claim is a counterclaim if one party asserts claims in response to the claim of another. Usually whenever something is done, one of the categories of other pleadings or papers that you put in will either be called an answer or a reply or a response. In other words, well, this man or woman said this. How do you respond? You can respond through something called a counterclaim. If the deadline for federal jurisdiction to be invoked as a form of counterclaim has run out, you can do it on a state level also. One of the ways is through the federal counterclaim, which is in that video. The two other ways will be explained in hearing, and the two types of counterclaims will also explain. In other words, if a plaintiff initiates a lawsuit and a defendant responds to the lawsuit with claims of their own against the plaintiff, the defendant's claim are counterclaims. A counterclaim is another word for subrogation, whereby it flips the position, turns you into the plaintiff, and turns whoever was once the plaintiff into a defendant. And in some case, if there's any risk to counterclaim, or at least if there's any question you ought to ask yourself is, well, if you do a notice of removal, or you do the second type of counterclaim, which we'll be going over, which requires you to open another case on a state level, just as you would with the first method, which is where you will open another case on a federal level. Does the old case to which you were presumed to be the defendant, does it run parallel to this new case? The short and quick answer to that is through something called a constitutional challenge in the old case, to put it on hold for 60 days. Within that 60-day period, if you know what you're doing, you'll have come to a very good conclusion, which is where other intricacies like the court administrative process comes in. But let's move on. Examples of counterclaim include after a bank has sued a customer for an unpaid debt, which is quite common. The customer counterclaims, aka sues back. When you sue back, that makes you a plaintiff. Whenever you sue someone, the one suing the other party is the plaintiff, hence a counterclaim. So what they're telling you here without telling you is, if the bank is suing you, the bank presumably in the initial circumstances a plaintiff and you're the defendant, you the customer counterclaim, aka sue back. When you sue back, you become the plaintiff, they become the defendant. And when you sue back, one of the ways you can also prevent the cases from running parallel so that you don't have to do a ping pong between two cases is to request an injunctive relief, aka a preliminary injunction in the old case. Remember, in the video regarding injunction, we went over the equitable aspect when it comes to private contract and a do not detain. But towards the beginning, we mentioned the other types of injunction that exist at law. Remember, a counterclaim is an at-law remedy. So now this is where competency comes in, because now once you open that counterclaim of yours as a plaintiff, you can actually request for a preliminary injunction in either or both cases to put on hold that initial case to which you were once a defendant. If that's not accepted, then you can still delay that other case so it doesn't run parallel through a constitutional challenge, which is an estoppel for a 60-day period. But there are many ways to skin the cat, and you can be creative about it and actually make it work. But let's not deviate too far into the details and just look at the general knowledge of what a counterclaim is. Most people think they get a counterclaim, but they don't. This world of legalese is very deep, much deeper than people going about getting people to just create documents for them. So listen very carefully. After a bank has sued a customer for an unpaid debt, getting people to create documents for you is good, but know the details. Know the details, or else the shock and the element of that mild depression that you feel when you lose something will hit you, because these people will not explain these details to you. They will just throw you that 12b6, which is just a blanket that says, we know you don't know what you're doing, and we're not going to explain it to you. 12b6, goodbye. You don't want that. And 12b6 is a federal one when it comes to the civil procedure. It applies at a state level. That term or phrase, failure to state a claim upon which relief can be granted, applies at a state level also. The exact verbiage, the section might be different, but the exact same principle is applicable. An example of what a counterclaim includes after a bank has sued a customer for an unpaid debt. The customer counterclaims, aka sues back, becomes a plaintiff, subrogates, counterclaims against the bank for fraud in procuring the debt, meaning there was no consideration, there was no full disclosure, there was no good faith involved. The bank has no money to lend out. The way that note was issued and circulated is not lawful. And if it's just based on private contract, based on private agreement, there was no full disclosure. There was bad faith, right? So fraud was involved. One of the elements of fraud, actual fraud, is that someone misrepresented a fact to you by virtue of them knowing that that fact is misrepresented, and they were aware that you did not know about it, so they omitted a fact from you to your detriment. That's a simple element of what actual fraud is. And that occurs a lot when it comes to notes and debt, etc. So you do your counterclaim and bring up one of those concepts and principles, right? Good. the court will sort out the different claims in one lawsuit. This is the important part. The court will sort out the different claims in one lawsuit. And then in parentheses, it tells you unless the claims are severed. Do you know what it means when it says unless the claims are severed? This word claims is referring to the claim of the one bringing claims against you. When you counterclaim, you're bringing a claim, hence a counterclaim. So you have your claim, they have theirs. The way you sever it is through opening different cases. So you can do that through a federal case, but what if the federal deadline is up? The second way is to open in the same court and do a notice of counterclaim in the old case where you were the defendant, and then do a regular verified complaint in the form of a counterclaim in that same jurisdiction, and then implement those other methods so that they don't run parallel, or so that you don't get things confused. Or if you want, if you know how things work, you can use the fact that they're running parallel to your benefit. So those are the two ways to do a counterclaim. You can sever it on a state level or on a federal level, or you can just keep it going on the same. But let me give you a caveat about keeping a counterclaim within the same suit. When you keep a counterclaim in the same suit, there's a maxim that says the plaintiff is the master of the suit. Plaintiff is the master of the suit basically means the ones that predominantly has the upper hand, the one to which preponderance of evidence in civil case or evidence beyond reasonable doubt favors in any given case is the plaintiff. Just like they'll bring charges against you and just throw in a police report and a complaint, and then you have to fend it off. That term or that title or that position called defendant is someone who has a presumption of guilt. Hence, you have to fend off the claim. And the only way you can effectively fend off a claim is by removing the presumption of guilt. Presumption of innocence does not exist by itself. Presumption of innocence exists when something triggers it, called an affirmative defense. If you're a defendant, then you have to trigger presumption of innocence by doing an affirmative defense. You have to use a tool that matches the position that you're playing within that court. So if you're playing a counterclaim within the same suit, it doesn't favor you because the master of the complaint or the master of the suit itself is the plaintiff, and you're just secondary. You're playing catch up. You don't want that. You'll always be in an inferior position if you don't sever the claims in different suit. And guess what? When you hear people talk about, oh, they create a different court case for the same case so they can trick you, they're not tricking you. What those people are doing on the other end is just a counterclaim. When someone is ignorant of how things work, they take one thing that's going on without comprehending that there's actually a system as to why that works the way it does. And they just loosely throw it out there and everyone accepts it and say, oh yeah, one of the tricks they play is they separate the cases. Yes, they do, because they can do that. And the way they do that is called a counterclaim. Most people don't know that counterclaims are being done against them. For instance, one of the things that actually triggers counterclaim against people in cases where they start to split up case numbers is when people do a Quo Warranto and they discretionarily accept that Quo Warranto. People don't know when they do Quo Warrantos on a state level, which is discretionary. Quo Warranto is only applicable to federal level. But when they do that Quo Warranto on a state level and somehow they accept it, it warrants a counterclaim. Do you know that? So now most people find all these templates, just put in this, put it in that. A counterclaim is effectively done against you once you do that Quo Warranto. Now they open a specific case to show the proof. And if you don't respond to that other case, they just proceed to your detriment. And now people come back crying and whining about something going on. When in truth, at first, a Quo Warranto is just saying by what warrant. Quo is just a Latin word for what. Warranto is just a Latin word for warrant. By what warrant do you have the ability to do this? And it's a federal remedy. It's a discretionary thing called a supplementary jurisdiction for a state court. to acknowledge Quo Warranto. And when they do, they will do it in form of a counterclaim as a separate open case because it's procedural due process in their part. How many people know this? And the thing is, a Quo Warranto is really not even where you want to go, because with a Quo Warranto, they can do a counterclaim. Instead of a Quo Warranto, you should be doing a constitutional challenge, because a constitutional challenge challenges the constitutionality of the case. The only thing that allows them the power to be able to do what they're doing is the Constitution. So if you challenge the constitutionality, you're by default automatically asking them by what warrant can you do this. If you're saying I'm challenging the constitutionality, you're affirmatively letting them know that by what warrant are you doing this. And then you bring in an attorney general, which you're supposed to do anyway, which is a standby attorney for all the prosecutors that's aka bringing cases against you, aka prosecuting you. So the proper way to cover all your bases is a constitutional challenge, because it does the exact same thing as a Quo Warranto by bringing in the attorney general, and it acts as an estoppel. A Quo Warranto does not act as an estoppel. Constitutional challenge does. People are running after the wrong remedies to their own detriment. But anyway, the second example of a counterclaim is two cars collide after one person sues for damage to his or her car and personal injuries. The defendant counterclaims for similar property damage and personal injury claims. United States. U.S. federal courts, counterclaims can arise in various occasions, including, for example, an attempt by the defendant to offset or reduce the amount implication of the plaintiff's claim, a different claim by the defendant against the plaintiff, claim by an impleaded third-party defendant against the original defendant acting as a third-party plaintiff, a claim by any party against another party who has made a cross-claim against them. We're not looking for a cross-claim. We're looking at counterclaim. Cross-claims are a whole specific matter of their own. Cross-claim is just basically when someone is snitching on the other. Cross-claim is you and I are both a plaintiff, and I'm like, you know what, screw you, my fellow plaintiff, I'm going to sue you. Or you're suing more than one parties, and they go against each other and start pointing fingers. A cross-claim is made when a defendant sues or makes a claim against his or her fellow defendant, or when a plaintiff makes a claim against his or her fellow plaintiff. When people playing the same position in the same case makes a claim against one another, that's a cross-claim. But that's another thing for another day. Let's look at counterclaim, which mainly deal with opposing parties who are flipping the position. Depending upon the location of where the lawsuit was originated, the defendant party has a period of time to file countersuit. Look at these keywords. They're telling you a countersuit and a counterclaim is the same thing. When you make a counterclaim, you are effectively suing someone. And look at that. They also tell you you have a time period for it. We've already went over that right here. If you're doing it on a federal level. Dependent upon the location of where a person was originated. In other words, the jurisdiction. The state has their own criteria. Federal has their own criteria. The defendant party has a period of time to file a countersuit, also known as a counterclaim. In other words, once more, if it's not clear, whenever you're saying I'm doing a counterclaim, what you are saying is you are suing them. When you sue them, you become the plaintiff. If someone is already a master of their claim and the master of this suit, or the master of the complaint itself, whereby they are bringing you as a defendant, and you choose to do a counterclaim under the same suit, you are automatically killing the power and the significance of a suit by killing the power and the significance of you being the master of your claim and complaint. Hence, the most effective way is to actually sever the claim. When you try to do a counterclaim under the same case itself, what you're doing is trying to mix recipes that don't go together. Don't do that. It's detrimental to you. Depending upon the location of where the lawsuit was originated, the defendant party has a period of time to file a countersuit, also known as a counterclaim, against the claiming party. In other words, you segregate and flip the switch. This is a direct claim from the defendant party against the party who initiated a lawsuit for concurrent claims. Concurrent meaning it's running side by side. They are using this word to let you know you are supposed to open your own suit. If your claim is that you're doing a counterclaim, then you should be opening a separate case, including being wrongfully sued. Now tell me, A cross claim is a pleading made against a party who is a co-defendant or co-plaintiff, blah, blah, blah. We're not going to read that. We're not looking at this. We're going to counterclaim. So now the two types of counterclaim under the Federal Rules of Civil Procedure. Counterclaims are either compulsory or permissive, and this is a Rule 13, which we'll go over. The first is permissive counterclaims. Permissive counterclaims comprise any claim that is not compulsory, that is not necessary. Such claims may be brought, but no right are waived if they are not. Courts rarely give permissive counterclaims the necessary supplemental jurisdiction to be brought. Remember the video on supplemental jurisdiction? Right. Go to that video and comprehend what supplemental jurisdiction means. Supplemental jurisdiction is just a discretionary thing that they respond to as a secondary thing, so long as it's leaning on something else primary called the original jurisdiction. In other words, a permissive counterclaim is nothing but a supplemental jurisdiction. Let me tell you right now, whenever you sue as a counterclaim under the same case, that's a permissive counterclaim. In other words, a supplemental jurisdiction to which the acting judge looks at based on discretion. Again, when you do a counterclaim, just open a new case and do a notice of counterclaim in the old one and put that one on hold through an estoppel or through an injunction. Simple as that. And the purpose of doing that mandatory injunction or preliminary injunction in that old case is to validate the claim. That whole thing about show proof of claim until this is happening, that's what a counterclaim is. And this is the proper way to do it. I'll repeat it again. That whole thing about people going about except for value, show me proof of claim until this and that, what they're trying to do is called a counterclaim. And this is the proper way to do it that we're explaining. Not all that other bullshit people do. Just being honest here. The woes of this world are the everyday man and woman's burden to bear. And ignorance make that great burden much heavier than it should be. Learn how things actually work so that you get it. Once you get it, you will have no need to run away from these court systems. You'll be going there to get things done. There's a reason why every time these people do something, they end it in a court system. Have you noticed that? Child support, oh, court system. Traffic case, oh, court system. Oh, you held a firearm, oh, court system. Mortgage, oh yeah, court system. They use this court system as the end game because there's something to it. There's money to be made there. It's just a way to launder money by giving it a cloud of legality. That's the simplicity of it. Maybe we shouldn't use the word launder. It's a way to put money in your pocket by making it legal. We'll put it that way. A claim is a compulsory counterclaim if, at the time of serving the pleading, meaning when you join the party. Now, here are the intricacies now. When you see this time of serving the pleading, they're speaking about summons and the joinder of party here. A claim is compulsory counterclaim if, at the time of serving the pleading, the counterclaim arises out of the transaction or occurrence that is subject matter of the opposing party's claim. Meaning, in the process of the other party making a claim to you, they damage you. That's the first element of a compulsory counterclaim. 2, and the counterclaim does not require having another party over whom the court cannot acquire jurisdiction, so long as the court can acquire jurisdiction and you intend to add another party, meaning, hey, in the process of you doing this to me in this suit, you harmed me, and oh look, someone else was involved. So long as that someone else that was involved can be joined properly through jurisdiction of the court, not a problem. Not a problem. Which is the second element. Third is, and when the action was commenced, the otherwise mandatory counterclaim was not the subject of another pending action. Meaning, this thing that you're now bringing up as a counterclaim, you haven't already brought it up in the first place. It's not already pending. Otherwise, it would first have to be dealt with before you now bring something else. So that it's not repetitive, so that it's not cumulative, so that it's not a waste of time. And the fourth element is Either the opposing party sued in its claim by a process that established personal jurisdiction over the pleader and the claim. Join them through service of process is what this is saying. Or if personal jurisdiction was not established over the pleader asserts some other mandatory counterclaim. A compulsory counterclaim. A compulsory counterclaim is when you sever the claim. A permissive counterclaim, meaning the discretionary one, is supplemental or a side thing that they can ignore because there's already a master of the claim called a plaintiff, to which they are suing. That's called a permissive counterclaim. It's a discretionary, it's supplementary. It's maybe we'll look over it or not. But look, there's this first in line claim against you though. So if you do a permissive counterclaim, which is under the same case to which you're being sued, it's supplemental. If you do a compulsory counterclaim, you've severed the case and opened a new one, so long as it arose out of that initial one that you're coming out of. And two, you can acquire jurisdiction over any other party if you intend to add extra parties. And three, if the claim that you're bringing as a counterclaim is not already taking place in other cases. And lastly, you're able to join them through service of process, aka personal jurisdiction. Very, very simple. Very, very, very simple. It's not complex. It's very simple. In other words, we just went over all this to let you know that there are three ways to invoke a counterclaim. And there are two types of counterclaim. The first type of counterclaim is a permissive one, which is doing a counterclaim under the same case number to which you were sued. It becomes discretionary, supplementary. They can ignore it if they want because you're not the master of the suit. That's the first type of counterclaim, which is a permissive counterclaim, which is one way to invoke a counterclaim. The second type of counterclaim is a compulsory counterclaim, which goes along with the two ways to invoke a counterclaim, which is through removing it to a federal level through a notice of removal, which we go over in this video, or to do it in the same jurisdiction in the state court by just opening a different case within the same court. So long as the claim that you're doing as a counterclaim arose out of the ongoing situation where someone made you a defendant, and if you intend to join an extra party, so long as you can join them through summons, and if the claim that you're making as a counterclaim is not currently ongoing in other cases, and the one that you're making a counterclaim against can be served a summons of the proceeding. Simple as that. Very, very simple. Those are the two types of counterclaims and the three ways to invoke them. The first way to invoke a permissive counterclaim is under the same case. The two other ways to invoke a counterclaim is a compulsory one, whereby you take it to a federal level or you do it at a state level. One thing those two things have in common is that new cases get open, which effectively and properly makes you a master of the complaint, aka a plaintiff. The secret is in a word. Look at that word complaint. Look at the suffix of it, plaint. Now take that suffix plaint from complaint and look at the word plaintiff. The suffix from complaint is the prefix in plaintiff. It's a little secret right there when it comes to legalese and words. So all these people going on about plaintiff, defendant, one thing or the other, you gotta call yourself this or that. Look, cut all that crap out. Look at the truth of how words actually work. Stop creating some doo-doo, smearing it on the wall, saying that it's some artistic rainbows and unicorn. Something is wrong with that. And most people are going over here worrying about saying you don't call yourself a plaintiff, you don't call yourself a defendant. No. Just look at the simplicity of how the English language works. Stop making up some BS just to make yourself feel good. Don't do that. You're running away from the problem itself. Let's go to Rule 13. Rule 13. Federal Rules of Civil Procedure. The same exact verbiage exists on a state level. Rule 13. Compulsory counterclaim. In general, a pleading must state as a counterclaim any claim that, at the time of its service, you have to join them. And if you want to join other parties, you have to be able to join them so long as they're under the jurisdiction of the court. Which is two of the elements, which is the second one and the fourth one. Second one applicable to the one to which you're doing a counterclaim against. The fourth one applicable to extra parties that you're joining into it. So the extra parties that you're joining, that's a new suit. It's not a counterclaim against them. It's just a whole new suit. To the one that you're doing a direct counterclaim against, it is in fact properly a counterclaim. In general, a pleader must state as a counterclaim any claim. Of course, this thing where it says any claim, presumably you know what you're doing, not just throw some crap out there. The pleading must state as a counterclaim any claim at the time of the service. In other words, it's telling you when you now do a counterclaim, you have to do it just like you do any regular new open suit. You have to issue a summons, do the regular normal stuff. The only thing that makes it a counterclaim is that you would make reference to the old case. And within the old case, you would do a notice of counterclaim pointing to the new case. In other words, when you do a counterclaim, you will open it regularly as a new suit. And then once you get that case number and whatnot, you will now do a notice of counterclaim in the old one and just point to it, just like you do a notice of removal, which is also a form of counterclaim, but on a federal level. You see? Very simple, not complex, not hard. These are some of the secrets in plain sight. Literally, it's a secret in plain sight. Counterclaim. It exists on your respective state level civil procedure. See, when people talk about on all these social media posts, when people tell you, I'm going to show you some special equity, you subrogate them, you do this, they start using all these buzzwords and these dictionaries, the obligor, this, subrogation, equity. If they're just throwing all those buzzwords and they're not explaining to you what counterclaim is, it's synonymous with them farting out of their mouth. They're just all that air coming out. Now imagine it being a form of a fart, and they just converted it into text and put it in social media. All these people eating that stuff up. If they're not talking about this when it comes to subrogation, they're full of shit. They're lying to you. Compulsory counterclaim. In general, a pleader must state as a counterclaim any claim that at the time of service the pleader has against an opposing party if the claim A arises out of transaction or occurrence that is the subject matter of the opposing party's claim, as we've explained, and B does not require adding another party over whom the court cannot acquire jurisdiction. The second element is not telling you that you cannot add a party. It's just telling you that so long as you add a party to which the court can acquire jurisdiction, then it gives you exceptions, just like any hearsay or just like any form of evidence. There's always exception. The pleader need not state the claim if, when the action was commenced, the claim was subject of another pending action, just as we've read here as part of the elements, which is the third one, or the opposing party sued on his claim by attachment or other process that did not establish personal jurisdiction of the pleader in the claim, and the pleader does not assert any counterclaim under this rule. In other words, you need to serve them a summons. If you look on the federal level, which this is another thing a lot of people don't know, when you want to attach someone, a video on this was done, a two-part video was done. The same form that you use with the U.S. Marshal to a service of process is the exact form that you use for attachment of properties. Did you know that? They're making reference to this loosely. In other words, this first few part of compulsory counterclaim has a lot to do with Rule 4, which is dealing with summons. Nonetheless, permissive counterclaim, which is one that you would do under the appended case, which basically is kind of weak and is basically a supplemental jurisdiction. On Patreon, we went over supplemental versus original jurisdiction is. A pleader may state as a counterclaim against an opposing party any claim that is not compulsory, meaning it's discretionary. If it's not compulsory, it speaks for itself. It's discretionary, it's supplemental. They can permit it or deny it as they choose. It's not by rights. Relief sought in counterclaim. A counterclaim did not diminish or defeat the recovery sought by the opposing parties. But it doesn't say that you can't do an injunction in the other case or an estoppel on it. It may request relief that exceeds an amount or different kind from the release. Blah, blah, blah. And then it goes if you want to do it against the United States, if you want to do it after acquiring pleading, blah, blah, blah. But that is the basics of a counterclaim. This was originally meant for Patreon, but it'll be placed on YouTube because it seems like many more people are ignorant of these things. And after these calls, speaking with people, you realize people are getting others to create documents for them that's fucking them up. They don't even realize it. Some of these things that they're doing, it seems reasonable to them, but in the long run, they'll be hit with a cloud of darkness and dismay that, oh crap, this thing that I've done only screwed me up. You don't want to get there before you learn better, but some people only learn the hard way because people take in information just to conform it to what they want. They want to use information just to fit their varying degree of information. When in truth, the reason why you're learning information is to increase your awareness, is to increase the degree of mind that you have, not to take that new information and bind it to your own limited perception of awareness. This is the main problem many people have. Hence, the woes of this world is the burden of the everyday man. Some people will never learn. Hopefully, you're the exception. Know better and do better. Don't be a simple-minded man or woman just following what other people tell you because it sounds good. Learn the details. Be competent. This thing people call freedom or right, you will never be free. And your right will never be enforced if you don't allow competence to act as a compass. If you don't allow competence to be the preceding and the primary factor. Otherwise, you're just fucking around. Get to it. Be serious enough about your life to be competent about how it works. Until next time, take care. Best of luck. Because you'll really need it. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people, make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that are on YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the Express Trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More in discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how, and the importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference and the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies, tax evasion. We show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it, and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things of nature, how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.